Probably one of the most common misconceptions I hear about domain name disputes is that a company can file and win a UDRP complaint against anyone who simply has a domain name that is identical to its trademark. This broad statement is not only an oversimplification of the entire domain name dispute system, but it ignores many of the other important factors that always must be taken into account in deciding whether to file a UDRP complaint in the first place, including especially when the domain name was registered. Hi, it's Doug Eisenberg, and the case I'm talking about here is not really unusual in any way, but it was just published in November 2021, and it's a perfect example of the misconception that I'm talking about. The case was filed under the UDRP, the Uniform Domain Name Dispute Resolution Policy, by a company called Property Tax Partners, and it involves the domain name ptp.com. Now, whenever I see a domain name dispute involving a 3-character .com domain name, I'm immediately curious to know what it's all about, because these short domain names are among some of the oldest and most valuable domain names, which usually means either that the dispute involves some unusual factual or legal issues, or that the party filing the dispute may have misunderstood how the UDRP works. And it seems like that's exactly what happened in the ptp.com case. According to the UDRP decision, Property Tax Partners owns a trademark registration for PTP at the U.S. Patent and Trademark Office. Here's a copy of the company's trademark registration certificate, which shows that Property Tax Partners is a Texas entity and that its trademark is for use in connection with the representation of clients in tax matters before tax authorities. In the UDRP dispute, the registrant of the domain name was an entity known simply as FCSE in Illinois. And in a response filed in the UDRP case, the registrant said that it purchased the disputed domain name for use in connection with its engineering services. Now, based on those facts alone, that the complainant is in the property tax business and the respondent is in the engineering business, it's easy to see that there may have been some challenges for Property Tax Partners to win this UDRP dispute. But the UDRP doesn't depend on traditional concepts of trademark infringement. So it's certainly possible for a trademark owner to prevail even without establishing a likelihood of confusion. However, Property Tax Partners had a much larger problem here. Specifically, its registration for the PTP trademark was not issued until 2020. And although it claims a date of first use in commerce that dates back to 2006, this is still after the ptp.com domain name was registered. In fact, the Whois record for the domain name shows that it was created all the way back in 1995, which was in the early days of popular domain name registrations, although FCSE said that it acquired the domain name 3 years later in 1998. Now, the registrant of the ptp.com domain name apparently knows that its registration is in high demand because it publishes a note on the homepage of its website that says, "We get a lot of inquiries about this domain, and at this time, we are not interested in selling." According to the registrant's response in the UDRP case, Property Tax Partners offered $1,000 for the domain name, and the registrant refused to make a counteroffer. In any event, the fact that the domain name was registered long before the complainant's trademark rights arose was the deciding factor in the UDRP case. As you may know, the UDRP requires a trademark owner to prove that a domain name was registered and is being used in bad faith. And although there are some broad interpretations of what bad faith actually means, the general understanding is that a domain name could not have been registered in bad faith with respect to a trademark that did not even exist at the time of registration. Here's how the panel put it in the ptp.com decision. Respondent claims that it acquired the disputed domain name in 1998. If that claim is true, then the panel must find that respondent did not register the disputed domain name in bad faith with respect to complainant or its service mark. As in 1998, complainant had not yet used its PTP service mark and thus did not possess rights in that mark. While respondent provides no concrete evidence to support its claim date of disputed domain name acquisition, complainant presents no evidence to counter the claim. As the overall burden of proof with respect to this element falls upon complainant, The panel must conclude that complainant has failed to sustain that burden as required under the policy. Therefore, the panel finds that complainant has failed to prove that the disputed domain name was registered and used in bad faith. Now, this decision is not at all surprising. It's consistent with the WIPO overview, and plenty of UDRP decisions have reached the same conclusion. Subject to some narrow exceptions, a domain name registration is not in bad faith if the trademark owner did not acquire its rights until a later date. As I said at the outset, this seems to be one of the most often misunderstood issues in domain name disputes, at least by smaller companies or those not using attorneys with experience under the UDRP, even those with litigation or intellectual property law experience. This case is a good reminder that proper evaluation of a potential domain name dispute is always essential. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other internet legal issues. Thanks for watching, and see you next time online.